Assalamu alaikum. I am reading a report from Supreme Court Observer. Please listen to it. Pendency of bills before Tamil Nadu Governor. Judgement summary. On 8th April 2025, a division bench of Justice J.B. Pardiwala and R. Mahadevan unanimously held that the Tamil Nadu Governor R.N. Ravi's withholding of 10 state legislative bills was illegal and erroneous. In doing so, the bench clarified the powers of the governor under Article 200 of the Constitution. The bench also used its discretionary powers under Article 142 to hold that the bills which were pending assent and reserved for the President were deemed to be assented. The bench also laid down timeliness within which the Governor and the President are to communicate their decisions on bills placed before them. Additionally, it expanded the scope of judicial review for a governor's actions, enabling state governments to approach courts and seek a writ of mandamus if these timeliness were not followed. A writ of mandamus empowers a competent court to direct a government official to discharge an official duty. At the outset, Justice Pardiwala wrote that once a state legislature passed a bill, it has to be mandatorily placed before the governor for his consideration. On receiving the bill, the governor may choose only one of the three options under Article 200: grant assent, withhold assent, or reserve the bill for the President's consideration. These options are mutually exclusive. If the governor withholds assent, the first proviso of Article 200 kicks in. It requires the governor to return the bill to the legislature for reconsideration. The state legislature may or may not accept the governor's suggestions. Once the bill returns in the second round, the governor must grant assent and cannot withhold it again. If the governor believes that the bill derogates the powers of the high courts, he may reserve it for the President under the second proviso of Article 200. The President would grant or withhold assent as per Article 201. In the present case, Attorney General R. Venkataramani had argued that the governor can withhold assent without sending the bill back. This would amount to an absolute veto, causing the bill to lapse without further action by the state. The Tamil Nadu government had opposed this view, citing the state of Punjab versus Principal Secretary to the Governor of Punjab, 2023. In Principal Secretary, the top court held that withholding assent is only valid if the governor returns the bill to the legislature. Venkataramani had questioned this interpretation and instead relied on Union of India versus Valluri Basavaya Chowdhury, 1979, where a constitution bench observed that a bill falls through unless the procedure indicated in the first provision is followed. The court examined Principal Secretary in light of Valluri Basavaya Chaudhary. However, the bench rejected Venkataramani's argument as short-sighted and half-baked. It noted that while a state legislature could delay reconsideration of a returned bill, the bill only lapses if the legislature chooses not to act. The prerogative to reconsider lies with the state, not the governor. If the governor withholds assent, he must return the bill as soon as possible. The governor does not have the discretion to withhold and sit on the bill without returning it. Hence, he cannot exercise an absolute or pocket veto. Justice Pardiwala found that Valluri Basavaya Chaudhary reinforced the connection between withholding assent and the procedure in the first provision. Therefore, Principal Secretary was correct and not Parliamentarian. He also cautioned that if Principal Secretary were incorrect, it would imply that the governor could exercise an absolute veto under Article 200. A bill considered by state legislature cannot be reserved for the president. Justice Pardiwala held that Article 200 limits the governor to just one of the three options. Therefore, if the government withholds assent to a bill and the legislature reconsiders and sends it back, the governor cannot reserve it for the president's consideration. This is because by withholding assent, the governor exhausts one of the options under the provision. He wrote that there is a strict constitutional prohibition against the governor to not withhold assent. However, the judgment also presented a possible scenario where the legislature's reconsidered bill can be reserved for the president. This could happen when the legislature introduces fresh changes to a bill that are not recommended by the governor after he returns it. Such a bill must be considered on wholly different and new grounds. However, the bench clarified that if the bill is amended solely on the governor's recommendations, the governor cannot reserve it for the president. The court cited this scenario to buttress the point that the first provision of Article 200 cannot be construed as giving the state legislature the unfettered power to introduce changes to the bill which alter its very nature in the second round. In Tamil Nadu's case, the governor withheld assent to 10 bills and returned them without any accompanying message. At that time, the court had already delivered the Principal Secretary decision, so it was expected that the governor would send a message. In the absence of such a message, the Tamil Nadu legislature reconsidered the bills in their entirety and sent them back to the governor. However, the governor reserved them for the president in the second round. This was not permissible. Timeliness for the governor to act on bills. Senior advocate A.M. Singhvi, appearing for Tamil Nadu, had argued that the phrase "as soon as possible" under Article 200 for granting assent effectively allowed the governor to sit on a bill indefinitely. The bench examined several decisions that dealt with timeliness and the interpretation of phrases like as soon as possible or reasonable period. The court also noted the recommendations of the Sarkaria and Panchi commissions, which suggest timeliness for the governor to grant assent. In light of this, Justice Pardiwala found it necessary to prescribe timeliness for the governor to discharge his duties under Article 200. He clarified that prescribing a timeline does not amend the Constitution, as it introduces no underlying change to the procedure under Article 200. On the contrary, it only reinforces the sense of expediency and urgency that the provision was meant to signify. Moreover, the timeline, he wrote, does not function as a hanging sword over the governor. Non-compliance would not automatically trigger consequences. Rather, the timeline serves as a guiding prescription. Any inaction would be open to judicial review, allowing the governor to justify any delay in granting assent beyond the time limits. These limits prevent the governor from exercising a pocket veto over bills. If the governor delays assent out of reluctance or lethargy, then aggrieved governments could not be left without remedy. The delay could impede the law-making process and even affect the public perception of the elected government in future elections. This, the court said, posed a serious threat to the federal policy of the country. The court prescribed the following timeliness, relying on the decision in Hisham Meghananda Singh versus Speaker, Manipur Legislative Assembly, 2020, where a limit was prescribed for the Speaker to decide disqualification petitions. Acts of governor or president not exempt from judicial review. The judgment held that the governor may exercise discretion without the aid and advice of the Council of Ministers in two circumstances. First, when a state bill contains provisions that derogate the powers of the high courts. Second, where the bill mandates presidential assent, or when the Council of Ministers cannot function due to a complete breakdown of constitutional machinery. The court cautioned that the governor could thwart the entire legislative machinery of the state by reserving a bill for the president, and laid out the key issues of consideration. One, whether any discretionary action by the governor under Article 200 is subject to judicial review. Two, whether the president's act of withholding assent is also subject to judicial review. Three, if the governor's action are judicially reviewable, whether the discharge of the governor's functions remains non-justifiable. On this aspect, the bench noted that neither the governor nor the president enjoys immunity from judicial review under Article 200 and 201, relying on Rameshwar Prasad versus Union of India 2006. The bench reiterated that Article 361, which grants immunity to the constitutional heads, does not bar courts from examining the actions of the governor. The court then addressed whether it was appropriate to review actions of the governor or president that are primarily political in nature and therefore non-justiciable. To clarify this, the bench cited S.R. Bommai versus Union of India 1994, which held that legal questions disguised as political ones are still justiciable. In the present case, the Tamil Nadu government had contended that the governor's withholding of assent was politically motivated and not bona fide. In response, Venkata Ramani had argued that the president's decision after the governor reserved the bills was not justiciable under HS Pharmaceuticals versus State of Bihar 1983. Justice Pardiwala noted that this position was reinforced in BK Pavitra versus Union of India 2019, which stated that the governor's act of reserving a bill was beyond judicial scrutiny. The bench disagreed with the view in BK Pavitra. The absence of judicial review, the court warned, would effectively shield the governor's actions in a lead casket that remains impenetrable even in cases of constitutional violation. On the last question about the president's grant or denial of assent under Article 201, the bench acknowledged that such action carries a political hue since the president has the discretion to determine whether granting assent is appropriate in cases involving union primacy or national policy uniformity. However, when the matter does not involve union primacy, the president's action is subject to a higher degree of judicial scrutiny. The bench then summarized its findings. Once the governor reserves a bill, he must record his reasons and clearly indicate the specific provisions that invoke the second proviso to Article 200, that is, provisions that derogate the powers of the High Court. This action is justiciable. A competent court may fully adjudicate the matter and approve or disapprove the governor's reservation. The court can also issue a writ of mandamus directing the governor to take appropriate action. This procedure applies equally to bills that require presidential assent. A state government may approach a court to seek a writ of mandamus if the governor fails to act within the prescribed time limits. A timeline for the president under Article 201, the president has only two options: either grant or withhold assent. If the president withhold assent, she may return the bill to the state legislature through the governor along with a message. The legislature must then reconsider the bill within 6 months, and once re-enacted with or without amendments, it is placed before the President again for consideration. The judgment held that the President cannot withhold assent without recording reasons in the first or second instance, as the Constitution does not provide for an absolute veto. The President may withhold assent only for those bills that specifically fall under constitutional provisions requiring her assent. However, unlike the governor, the President is not constitutionally obliged to assent to a bill that is reconsidered. The bench also observed that Article 201 does not specify a timeline within which the President must act on a reserved bill. As a result, if the President does not take action, the bill remains in an indefinite and uncertain state of abeyance. While the court acknowledged that the President's consideration of a bill may not easily be confined to rigid deadlines, it is stressed that this cannot justify inaction. To address this, the court relied on two mandamus issued by the Ministry of Home Affairs in 2016, which prescribed a time frame for the President to decide on reserved bills. Considering the procedural steps involved, the bench directed that the President must decide within 3 months. If the President fails to act within this period, the affected state government may seek a writ of mandamus from the court. The judgment further clarified that any preliminary objections raised through internal communications as per the memoranda cannot substitute the formal message that the President is required to send under Article 201. A genuine dialogue must occur between the President and the state government. If the state legislature expresses a willingness to reconsider the bill, it may go through a second round. In this round, the President may either grant assent or withhold it, thus effectively terminating the bill. However, any decision to withhold must rest on clear and sufficient reasons to ensure that it is not equivalent to exercising an absolute veto, as there has been prior deliberation between the state and the union. The wise and whereof force of the President's actions provide a basis for judicial review and allow the courts to assess the validity of the decision as well as ensure accountability between the three pillars of government, Article 142 and the deemed assent. The bench held that the governor's conduct, first withholding assent without a message and then reserving the bills for the President after reconsideration, lacked bona fides. It is difficult for us to repose our trust and remand the matter to the governor with the direction to dispose of the bills, the judgment said. In view of the unique and prolonged chain of events, the bench concluded that it was absolutely necessary and appropriate to invoke its extraordinary powers under Article 142 of the Constitution to deem the 10 pending bills as having received assent on the date of which it was sent to the governor in the second round. The provision allows the court to pass any decree or order to ensure complete justice. The court emphasized that this exercise of Article 142 was not undertaken lightly or routinely, but only after the deepest of deliberations.